Now, the Texas Tribune did another article. The Texas Tribune recorded that David Simpson of Longview on House Bill 41 pulled down the dramatic fashion, and Senator Dan Patrick of Houston, after the Department of Justice warned them officials its passage could violate federal law. The federal government has no constitutional right over Texas in that area. Let's face it, everything, ladies and gentlemen, everything, every power that the government has is specified in the Constitution. The Constitution is clear. They only have those powers limited in there. They do not have the power to demand Obamacare, for instance, health care. They do not have these powers. It's not in the Constitution. And it's time we got back to the Constitution of the United States. It's time we had our legislators get up and stand up for the Constitution, because they said that they would preserve, protect, and defend it, and they are not. Now, we need to get it clear. We need to back people who will be in the White House. We need to send citizens who are up there who knows what it's like out there, businessmen who knows what it's like out there to lose a business. We've had thousands, hundreds of thousands of small businesses go out in the last 2 years. It is terrible what's going on. Now, the Fourth Amendment makes it very clear that this groping law. Now, the Texas Tribune did that article, and the Fourth Amendment is really, it goes something like this. It says that the Fourth Amendment to the United States Constitution is the part of the Bill of Rights which guards against unreasonable searches and seizures, along with requiring any warrant to be judicially sanctioned and supported by probable cause. What brought about this rule was the fact that the King of England issued warrants of arrest and arrested people and went into their homes and took things from them at random, just like they wanted to, sort of like the federal government is starting to do to us today. They go in there and they were taking those things. And that's why that our forefathers put this in the Constitution, because their rights had been violated. And so therefore they put it in the Constitution so your and my rights would not be violated. But it seems like we just keep giving them up. So where do we draw the line? Where do we stand? We have to stand someplace. So it was adopted as a response to the abuse of the writ of assistance. Writ of assistance. There's terms we need to know, and this is one of them, writ of assistance. We're sort of like what we issue a warrant for your arrest today. Anyway, they just used them for anything. And finally, our people got to stand up and said, this is wrong. In 1967, the Supreme Court ruled that the amendment's protection do not apply where search party lacks a reasonable expectation of privacy. Let me go a little bit further. The Supreme Court has also ruled that certain searches and seizures violated the Fourth Amendment even when a warrant was granted. You cannot be searched unless there is a reasonable doubt that they have to, and it can't be just, well, I just have a whim, I think maybe that you're guilty of it. You cannot be, according to our Constitution, you cannot be searched unless there is a reasonable expectation that you have done something wrong. Now, there's a lot of other things in this thing, and believe me, it'll take a while to start studying the Constitution. But let me just kind of go through these for just a moment. Of course, we go back to English law. I just told you about where the English law allowed them to go in. And with this writ, they would go into the home and they would take things. Well, let me tell you what happened. In 1760, there was a man called John Entick, E-N-T-I-C-K. John, whose home was forcibly entered by the king's messenger, Nathan Carrington. It was called, the court case was Carrington and Entick, to make strict diligent search for the author of one concerning the writing of several weekly seditions. So he's writing papers against the federal government, revealing what they were doing. And so these pamphlets, they seized them. They went to court. And guess what? The court said no, there was no probable cause that this executive is limited to intruding on private property. You cannot do it. Entick won the battle. Now, in January of 1761, a group of over 50 merchants represented by James Otis. That's another name you need to write down in your memory. James Otis. James Otis. When the news of King George II's October 23rd death arrived in Boston, all the writs, these writs of of arrest, all these writs were null and void. And so they were all going to have to go back and get the king, the new king, to sign it. And so in the midterm January of 1761, a group of these 50 merchants represented James Otis petitioned the court to have a hearing on the issue. During the 5-hour hearing on February 23, 1761, Otis vehemently denounced English colonial policies, including their sanction of general warrants and writs of assistance. However, the court ruled against Otis because of the name he had made for himself in attacking the writs. He was elected to the Massachusetts colonial legislature and helped pass the legislature requiring that the writs of assistance be granted by any judge of justice upon information under oath by any officer, and barring all writs. Now listen to this. The governor overturned the legislation, finding it contrary to British law and parliamentary sovereignty, and John Adams, who was at that meeting at the courthouse on that day when Otis spoke, he viewed these events as the spark which ignited the revolution. It has to do with our Fourth Amendment constitutional rights. This is what CC asked me to talk about. I got one more quick thing, and this has to do with searches and seizures in the United States. And it says that privacy interests such as strip and body cavity searches must be supported by reasonable suspicion. The United States Court of Appeals for the Fourth and Ninth Circuit Courts have ruled that information on a traveler's electronic materials, such as personal files and so forth, can be searched at random. And so, what was that? Okay. And that's all that I've got. But I will say this one last thing. It's time we stood up. And if you're standing up as this group, then it's time we stood up and we took on the Constitution and we stood with Texas and the United States as well.
Thank you, John. Y'all, Dr. John Cooper is from Hopkins County, and he ran for Congress against Ralph Hall, if maybe some of y'all remember. And he'll be running again with the redistricting. We want to keep him in mind because he's very conservative, a very moral man. We need someone like that in office. As we concurred, all of us here do believe that we need to convene. We need to have a citizens' convention. So what we need from you tonight is, I think everybody signed the sign-in sheet. That's just so if we need to contact you, we can. We would need just your zip code and your email or your phone number. And what we would like for you to do tonight when you leave this place is to spread the word. If you have any family and friends who are in different districts, like in Dallas or Tarrant County or Rockport or out in West Texas, I don't care where, just tell them what we're doing. And what we're going to be doing is doing this in clusters. There is no head central person in this. Teresa and I organized this for the District 2, but we're going to be like, I call it the turtle game. We stick our nicks out there and we spread the word, and then we put our heads back in our shell and go away. This is a very protective thing. No one can come after us this way. They can't stop us this way because there's no one person they can shoot, so to speak. Clusters. Get your family and friends to talk about this. Have your little meetings. Encourage people. We need other districts to hold cluster meetings. We are ready here in House District 2 to make the initial formal call when we need to. We would like to have other districts sign that formal call with us, but we're ready to make it ourselves. But this summer, we would like to have these consultations being taken place in different areas of Texas. Now, let me remind you, too, you don't have to have a zillion people to do this and make it successful. The original one, I think the general population of Texas was, 600,000 people. The people who voted in this were 45,000. The west and the northern parts of Texas were not even involved. We would like to have more participation. We are not going to structure this over the internet. We want person-to-person contact. It's more effective and it's safer. I'm not promoting a revolution, come on now, and I'm not promoting secession. I am promoting a citizens' convention. We will use the internet for our expediency. To say you have friends that you like to contact on the internet, well, by all means, please do. But these meetings need to be face-to-face. We will have this video on YouTube next Thursday, and I do highly recommend that you, if you can, attend Dr. Cooper's constitutional meetings. They're going to be on Thursday night at the Pizza Inn in Sulphur Springs, because it's like he said, if you don't know the rules, how can you enforce them? And sad to say, they're not teaching about the Constitution in our government in schools anymore. Sam, I think you had a question back there. Would you like to say something?
It's just that maybe y'all could send something over the net that breaks it all down, where we can copy it off and pass it to all our friends. It doesn't have to have all the necessarily the names or anything, but what we're for in trying to do.
Okay, Stan wants to know if we can have it broken down where we can send it to other districts where they can have a game plan. And yes, we can. Basically, what they just need to do is have a meeting, and we do have a website. We could, where people can go and learn what a Texas Citizen Convention is. But do you all understand what it is? Did we make that clear tonight? Do y'all have questions about what a Citizens Convention is? This is a solution. This is not just protesting. This is actual doing something. And I think it relieves the paralysis that people feel nowadays, that they're in apathy and the paralysis that we feel because nothing's getting done. This does it. You actually are going to be doing something. You're giving a solution, and we're going to elect delegates. We need people to step up right in this district who will help us with the election process. It's not going to be difficult. It won't be hard, but we need people who will be there. I think we'll probably divide it by precincts, but we need to see how much dialogue is going to be in the community. We'll have another meeting in Van Zant. We had a meeting about 2 months ago in Rains County. This meeting is in Hunt County, and then we're going to go to Van Zant and have a meeting there and take the pulse of the people. But Sam, yeah, we basically this summer consultations, get the word out, get it into other districts. Those people you can tell them that they can call Teresa or I. It's that simple, like a little club. And then we will guide them, tell them what to do. We have a website where they can get information to read what a Texas Citizens Convention is. And if people feel that, like you all do tonight, that yes, it's time to call a Citizens Convention, then they will tell their friends and family in their district and get the ball rolling. Well, like I said, like Teresa said, the first time I met Teresa was at a town hall meeting, and she stood up towards the end of the meeting and read this letter. And at the time, they only had 26 counties signed for this Texas Citizens Convention. And I thought, wow, I thought this was it. Now we're up to 77 people have signed up from 77 different counties. There's 254 counties in Texas, and there's 150 House districts. We don't need to have 150 House districts sign on in order for this to be successful. I would say I don't know, but I would say even a third. If we could get a third of the House districts to sign, I think that would be very strong.